From this video, I expect to describe why a contract should have risk management clauses therein, and why it is beneficial for both sides of the contract. I'd discuss in detail force majeure clause, indemnity clause, and arbitration clause. The main reason to have risk management clauses in a contract is to mitigate any risk involved in their contract. It helps anticipate, identify, and mitigate potential risks that could arise during the course of the contract. There are a number of benefits for a contract to have risk management clauses therein. Risk management clauses provide clarity on how risks will be addressed if occurred, and helps both parties understand each other's responsibilities and how they should act in an unexpected situation. Next, it specifies which party is responsible for certain risks, so it reduces potential disputes. Thirdly, in a contract, both parties are driven by a set of interests. Risk management clauses make sure in an unforeseen circumstance how to protect one party's interest from the other party's action. Also, in a dispute between parties, risk management clauses guide the procedures such as mediation or arbitration to resolve disagreements. As a result, trust and cooperation between the parties are secured, and leads to maintaining relationships over the time being. Under force majeure clause, they are listing specific events or circumstances that qualify as force majeure events. For example, natural disasters, acts of terrorism, war, strikes, government actions. Then specify in the occurrence of such an event how the parties' obligations will work. Like temporarily suspension of performance. These clauses often require the affected party to provide a notice to the other party soon, including details about the event, its impact on performance, and an estimate of when normal performance can be expected to resume. Many force majeure clauses require the affected party to make reasonable efforts to mitigate the effects of the event and resume performance as soon as possible once the event has subsided. It specifies who bears the risk and potential liabilities associated with unforeseen events. Typically, if a force majeure event occurs, the affected party is excused from performance, and neither party is held liable for damages resulting from the event. Let's get clarified this relating to our example Vegetable Greenhouse Corporation. Think, they have include natural disasters in force majeure clause. If some natural disasters like storm occur and damages the vegetable yield, and farming company is unable to supply agreed upon quantities of vegetables to the grocery store, the farming company could rely on the force majeure clause to temporarily halt deliveries until the weather conditions improve, and request for an extra time period for delivery schedules. Or even add clauses to avoid penalties or liability for breach of contract. As well as if a disruption in transport occurs, the farming company could use the force majeure clause to temporarily halt deliveries or negotiate alternative transportation methods or routes. Indemnity clause typically begins by identifying the indemnitor and indemnity. The indemnitor is the party agreeing to provide indemnification, while the indemnity is the party receiving protection or compensation, outlining the types of losses, damages, claims, or liabilities for which the indemnitor will provide indemnification. For examples: third-party claims, breach of contract, legal expenses, product liability. The indemnity clause may include conditions and limitations that specify when and how indemnification applies, such as the indemnity must notify the indemnitor promptly of any claims or losses of indemnification. The indemnitor may have a duty to defend the indemnity against claims, and maximum liable amount of the indemnitor should be mentioned. This could include the timing of payments, the method of payment, and any interest or penalties for late payments. The indemnity clause may indicate how long the indemnitor's obligation to provide indemnification will last. Let's take our example companies into consideration. Let's say a customer of Grocery Store Inc., who consumed vegetables becomes seriously ill due to contamination. If there was an indemnity clause mentioned that the Vegetable Greenhouse Corporation agrees to indemnify and hold harmless the grocery store from any and all claims, damages, or liabilities arising from the consumption of its supplied vegetables. The indemnity clause ensures that the Grocery Store Inc. is not held financially responsible for product-related incidents, and it can seek compensation from the Vegetable Greenhouse Corporation. Arbitration typically considered as a faster resolution of disputes compared to litigation through the court system. Litigation is quite a lengthy process and expensive due to attached expenses such as attorney's fees, court costs, and other legal expenses. While arbitration often reduces these costs, Arbitrator is an expertise in a particular industry. Therefore, parties can expect that he would properly understand their nature of the business and the industry-specific issues. Companies sometimes do not like to disclose internal disputes to the public. Through arbitration, companies can avoid unnecessary publicity for their legal cases and protect confidentiality. Further, business prefer go for arbitration in order to preserve business relationships in the long run. Thank you for listening.